not a charity, it's a right. The law of maintenance is governed by personal laws, but there are two major loopholes. First, that different law applies upon different religions, so there is no uniformity with regard to the law of maintenance. Secondly, it is a time-taking process. So to overcome these difficulties, the law related to maintenance found place in criminal procedure law. But the provision under the procedure law is substantive in nature. Now, the law was governed by section 125 to 128 of CRPC. But with the enactment of new criminal law, that is Bharatiya Nagrik Suraksha Sanhita 2023, the provision is now governed by section 144 to 147 of the Sanhita. But there is no major change in the new criminal law. The substantive part of the law remains the same. Therefore, the judgment which were relevant under the CRPC also holds good under Bharatiya Nagrik Suraksha Sanhita. So if you are preparing for any exam, then these judgments are must to do. So watch this video till end. The first landmark case is Muhammad Ahmad Khan versus Shah Banu Begum, 1985 Supreme Court. It is also famously known as Shah Banu case. It is a judgment of Constitution Bench. In this case, the question arose whether the Muslim wife is entitled to claim maintenance under section 125 of the CRPC, because under personal law, the husband is bound to give maintenance only during iddat period and not after that. The Supreme Court discussed section 125 and held that it is a secular provision which is applicable on all religions equally, and there is no restriction or exception in favor of any religion. So, a Muslim wife is equally entitled to claim maintenance under section 125 of the CRPC after divorce till remarriage, and the personal law will not restrict her right in any manner. After Shah Banu case, there was a hue and cry among the Muslim community, and the government was forced to enact a law, that is Muslim Women Rights on Divorce Act 1986. Under this act, the husband was made obligated to make a provision for fair and reasonable maintenance for wife during iddat period. After this act, the case came up before the Supreme Court, that is Daniel Latifi versus Union of India and others, 2001 Supreme Court. Now, it is a constitutional bench judgment. In this case, the question arose whether the Muslim woman, after the enactment of 1986 Act, is entitled to claim maintenance after iddat period under section 125 of the CRPC or not. Now, the Supreme Court held that husband is bound to make a provision for fair and reasonable maintenance under section 4 of the 1986 Act during iddat period. If the maintenance paid by the husband during iddat period is sufficient for the divorced wife to sustain after divorce, then she is not entitled to file a case under section 125. But if the maintenance given by the husband is not sufficient and she is forced to live a life of destitute and vagrancy, then she is entitled to make an application under section 125 of the CRPC, and the 1986 Act does not restrict or eliminate her right to make an application. The third landmark case is Vijay Manohar Arbat versus Kashiram Rajaram Savai 1987 Supreme Court. In this case, the question arose whether a daughter can be made liable to maintain her parents, because under section 125 the expression used is his father or mother. The Supreme Court answered this question by referring section 2Y of the CRPC, which says that all words or expressions which are used in CRPC but not defined shall have the meaning which is defined under Indian Penal Code. And secondly, the court referred section 8 of the Indian Penal Code, which defines the term gender. It says that the word his and its derivative includes both male and female. Therefore, the word his used under section 125 shall also include her. Therefore, daughter is also equally liable to maintain her parents. The fourth landmark judgment is Badshah versus So Urmila Badshah Godse, 2014 Supreme Court. In this, it is a division bench judgment. In this case, the question arose whether the wife of a void marriage is entitled to claim maintenance from the husband or not. Now, under section 125, the expression wife is used, which means a legally wedded wife or a divorced wife. in no manner it includes the wife of a void marriage. But the facts of this case are that the husband marries the petitioner during his subsistence of first marriage, and the petitioner was not aware about the fact of first marriage. Now, when the petitioner made an application to the court for maintenance under section 125, the husband contend that she is not entitled to maintenance because she is not his wife, because he is already married and has a wife. Now, the court, after discussing the law, held that though under section 125 only a legally wedded wife is entitled to claim maintenance, but in no case a husband is allowed to take advantage of his own law. Secondly, if the court refuses to give maintenance to the lady, in that case, the purpose of the provision, that is to prevent destitution and vagrancy, will become redundant. Therefore, the court allows the maintenance application and granted maintenance to the wife of void marriage, but mentioned that the wife of bigamous marriage is entitled to claim maintenance only if she is not aware about the fact of her husband's first marriage. If she is aware, then she is not entitled to claim maintenance under section 125. The fifth important judgment is Rajneesh versus Neha and others 2020 Supreme Court. In this case, three major legal issues were raised with regard to the maintenance provision under CRPC. The first issue was with regard to the delay in disposal of interim maintenance application. Second was the overlapping of jurisdiction under different statutes. And the third and important is the date of enforcement of the order of maintenance. Now, with regard to the first issue, that is disposal of the interim application, the court held that generally the interim applications are decided on the basis of pleadings. Therefore, there are major guesswork which led to exaggeration of maintenance proceedings, and it takes years to decide even a interim maintenance application. So the court lays down that the parties of the maintenance application are bound to file affidavit with regard to the disclosure of their assets along with the maintenance application, which will help the court to decide the application in a time-bound manner. Now, second issue was overlapping of jurisdiction under different statutes. As a result of this overlapping of jurisdiction, the husbands were bound to pay maintenance under different statutes. As a result, it becomes more like a punishment for the husband than an obligation. So, to streamline it, the court held that the parties are bound to disclose about the previous maintenance proceeding and the orders passed in that proceedings. Now, the court is bound to consider the amount passed in the previous maintenance proceeding and shall set off that amount in the present order. With regard to the third issue, the court says that there is a confusion with regard to the date of enforcement of the order, because the provision says that it can be applied from the date of application or from the date of order. Now, a lot of confusion persists with regard to the date of enforcement. After discussing all the previous judgment, the court had settled down the position that the date of enforcement of the order is the date of application and not the date of order, because it will help to uphold the social purpose of the provision. I hope you like this video, and for more such videos please like, share and subscribe.